SJC-11634, Commonwealth v. Bolden.
Good morning, Mr. Adams.
Good morning.
Wait a moment, and then we'll start the clock, and you can get started. And you may now proceed.
Thank you. Mr. Chief Justice, and may it please the Court, William Adams, appearing for Maurice Bolden. There are two components to this arising from two different cases. One involved a housebreak in Agawam. Our contention is that the evidence before the grand jury showed only one burglary, simple burglary, that would in turn give rise to only one conviction and one punishment, more precisely, for aggravated burglary because of acts committed.
But we've had a trial. He's been found guilty beyond a reasonable doubt. What does it matter at this point?
Well, according to Connor and McCarthy, it doesn't matter that he received a fair trial if the grand jury proceedings were defective because of lack of evidence. And that is essentially our contention here.
But isn't the time to raise that pre-trial in a motion to dismiss?
Well, according to Lefebvre and numerous authorities cited there, you don't have to. The double jeopardy prohibition is against multiple punishments. I mean, we tolerate situations where, for example, a greater offense and a lesser included go forward on two indictments. And in this case, either indictment would have supported punishment. And so theoretically, I suppose you could have a case where both indictments were in the case, but the jury found there was no assault on one, but there was an assault on the other. As I make the point in the brief, it gets into also separation of powers problems because the Commonwealth theoretically controls what they're going to go forward on. And we haven't had any cases I'm aware of that discuss this precise situation.
Are you saying this case really is governed by Gordon?
Well, the principles discussed in Gordon do govern this case. In other words, if an offense can be committed by alternate means, commissioned by one doesn't mean you can then go ahead and select elements from one and then combine them and make up another, sort of like a smorgasbord approach, come up with another offense simply because two people were assaulted.
If you're right, if we do agree with you, that means one of the indictments should not stand, I take it.
That's correct.
Well, can that indictment be remanded for sentencing on the question of the assault of the second victim?
I think not, because there are cases, I've lost this argument in an earlier phase, that's why I'm remembering it, that the assault described in the aggravated burglary statute is not the equivalent of simple assault.
See,
I have the name on the tip of my tongue.
But one of the problems with proceeding that way is that it deprives the Commonwealth of the opportunity to have perhaps sought another indictment before the trial. If you had done this before trial, or other counsels, your predecessor counsel had done this before trial, the Commonwealth would have been in a position to perhaps seek an indictment for assault on the other.
But they did, actually. They also got, in this particular case, they did get a conviction for an assault. They got assaults on both people. And that's what I argued before. Another stage of the proceedings, that in fact that assault indictment should not stand because it's part of the aggravated burglary charge.
It should not stand?
The assault indictment, the separate simple assault indictment should not stand because of the aggravated burglary charge. And there are
but if the aggravated burglary charge is removed, there's nothing wrong with that assault, is there?
No, but there isn't anyway, because there's substantial case law that says simple assault is not the assault described in the aggravated burglary statute, that they have different elements.
Let me make sure I understand what let's assume you prevail in persuading us that it's duplicitous. Then there would be what the Commonwealth would have is an aggravated burglary conviction, one of them.
Correct.
And they would also have a separate assault conviction for the assault on the woman as she was at the top of the stairs.
That is correct.
And would the Commonwealth then be permitted, or would we basically remand for new sentencing so that if a judge wanted to give on and after time for that separate assault, the judge could choose to do so?
No, because there's been performance of the judgment.
Didn't he give
jeopardy,
concurrent sentences? I thought it was concurrent life sentences on these.
There were concurrent life sentences imposed on both aggravated burglary indictments and on the number of other indictments arising from the same episode. They were all concurrent, yes.
So,
But my point to Chief Justice Gantz is that once the judgment is performed, which it has been, you can't increase the sentence.
Let me shift the focus a little bit. If somebody, under the second theory under the statute, the second theory of breaking and entering, which is the entering and breaking.
That's right.
If the front door of a house is wide open and a person enters and then goes upstairs, and there are 2 bedrooms upstairs, the doors are closed, and there's a different person in each of the 2 bedrooms. And the defendant then opens each bedroom door and tries to rob the person who's inside, commits essentially one of these offenses by opening 2 separate doors after entering. Are those 2 breaks?
Well, there are 2 breaks, but there's only 1 entry, so there's still only a simple burglary. The statute tracks, and I hope I was persuasive in showing you the standard view of the treatise writers throughout the 1700s and the early 1800s, that there are 2 ways of committing simple burglary. One is breaking and entering, which is sort of what we think of. Someone opens a door and walks in. The other one is entry without breaking and then breaking somewhere in the interior of the house. But once you've done that, entering as you described, and then breaking, you have committed the predicate offense. And then whatever happens, it aggravates that offense. It increases the punishment beyond that of simple burglary, which there's a companion statute. It's 266, Section 15 to 266-14. They're clearly related. Sorry.
well, if that's what you say, and so you've committed the offense of simple burglary, in this case, by entering, and then you have the second break, and then you have the assault on
Mrs.
Is it
Glukowski.
Glukowski. So is the Commonwealth right in arguing that that's the additional offense for her, and for Mr. Glukowski, it's the being armed, getting armed inside with the 2x4?
No. The facts showed, I think they're undisputed, that Mr. Glukowski walked up to, Glukowski, I've got the wrong person now, Mr. Bolden walked up to the back door, opened it, walked in with felonious intent in the nighttime. That's the predicate offense.
That's the burglary, right.
That's the predicate offense. You cannot then go back and say, well, we do have an entry now, and now we have another. So we're going to say this is also the alternate offense, because these are 2 ways of committing the predicate offense, but they're mutually exclusive. Once you've done one, that's it.
But I guess what I was trying to say was, okay, you've done one, but the aggregating factor, I think this is the Commonwealth's argument in part, is different for each of them. That is for
yes
there's
and no.
3 ways
there
you
were
can
3
aggravate.
things. 3 things that happened. He armed himself with a 2x4, attacked Mr. Glukowski, and then attacked Mrs. Glukowski. So there would be 3 aggravating offenses. My point is that you establish the predicate offense, and then the aggravating factors, how many ever there are, fall into place.
So once the castle hold has been breached,
Exactly.
that constitutes a single breach, no matter how many assaults are committed inside the walls.
I believe so. And if you read the last 3 or 4 pages of Commonwealth versus Hope, which is the case, it's an opinion by Chief Justice Shaw that was cited in Gordon, lays out that theory pretty much, that that's the meaning of the statute. And Chief Justice Shaw actually specifically cited the ancestor of all of these statutes, this string of statutes, in 266, which if you compare I forgot, I think it's Chapter 101, 1805, Chapter 101. But if you compare that statute to what we've got, you see what we have basically today is the Reader's Digest version of those statutes. They stripped of extraneous language and so on. So Chief Justice Shaw was actually talking about our statute when he said so, and that's why it was cited in Gordon.
If this statute had been placed by the legislature under Chapter 265 instead of Chapter 266, would the result be different? Would it be sort of like
Well, there would be
robbing a
there would
bank?
be an argument, certainly, that could be made. I don't think the result would be different since the language tracks so specifically common law burglary as is traditionally received. It would be one of those odd situations where we know where they put it, but here it's unquestionably a burglary statute, and it refers to the possessory right or the right of use of enjoyment of one's dwelling or one's residence. And so
You can have one burglary and several assaults as well as several robberies of individuals
Exactly,
within the
exactly.
100, but still only one.
that's
Right.
my view. I mean, that's the
I
point. That's the
understand.
point I'm trying to make.
That's Gordon. I mean, that is what Gordon said.
That is essentially what Gordon's.
I mean, it's,
Right.
your
Exactly.
facts aren't quite as good for this proposition as
I
Gordon.
understand, but I think the rationale in Gordon and the reliance on Chief Justice Shaw's opinion and so on pretty well pushes us in that direction. Pushes me. I'm hoping it pushes you. I'm running low on time. If I may just quickly go to the Springfield case.
Could I just ask you one
yes.
question? You said the sentence has been performed. These life sentences have been performed?
Chief Justice Gantz was asking, Justice Spain, I forgot which, was asking about assault. Could we go back
that
for
one.
assault?
Oh,
And I was pointing out there actually was an indictment for assault, which was not duplicative, although I would like it to have been. And it's already been fully performed, so one could not then do more of that sentence. Besides, simple assault, I think, is a misdemeanor, and that sort of wraps that up. In the Springfield case, I think Snow is pretty clear. You cannot change the identity of the victim of an offense involving personal injury. And in Binkowitz, this court commenting on Snow says, essentially, the man, Snow, was convicted of a different offense for which he was indicted.
Would it be different if the facts as recited were different? As I understand it, I think the individual the older woman, said that she was assaulted, right? There was an older woman who said she was assaulted and a younger woman who actually was assaulted? No. Do I recall that correctly?
Oh, no, Snow is an extortion case.
No. I'm sorry. I'm
The
talking
older
about
woman
the
owned the house.
I'm
The
talking
older
about the
woman owned the
Springfield
house.
case.
No, the Springfield case. Oh, I beg your pardon. Okay, yes. There were two people.
Right. A mother and a sister,
daughter-in-law.
daughter-in-law.
It was a daughter-in-law.
Presumably one's older than the other, and then in the facts, I thought I recalled, would have supported the older woman's having been the person assaulted, but in fact, that wasn't the case.
That's exactly what
Okay.
happened.
Would it be different if it were
Right.
consistent with the facts, but the names were wrong? That is, a younger woman said she was assaulted.
If there's no question about the identity of the victim,
Right.
and they simply called that victim by
Right.
a wrong name,
You wouldn't have this
that's a misnomer.
argument.
In
Okay.
other words,
So this is different
this
because
was
of-
the individual, the man with blonde hair and so forth and so on, who was hit. And his name was John Smith. So it wasn't John Smith, it was Al Sudry. Okay, that's a misnomer. But when you have a situation where there are two different persons in being and only one is described and one is not mentioned at all, you cannot draw an inference that the grand jury had in mind, and that's the critical question, had in mind the person who wasn't described in the evidence. Mookin, Justice Learned Hand's decision, is really a fascinating short discussion about something very, very similar. It's cited, I cite it in the brief, it's cited in Distasio, which in turn is kind of a gloss on Snow.
But in those cases, was there an agreement, as there was in this case, to amend the indictment?
That's precisely the point I'm coming to. I think the difficult issue in the case is what to do in the situation where there is agreement to do this. And in my opinion, it depends on whether or not the prohibition, which is what I argue, the prohibition on amendments of this kind goes to the jurisdiction of the court. Does the court have power to do this? Since it's substantive, my answer would be no, because even under Rule 4D, which simply carries forward that since superseded statute that was construed in Snow, 277, Section 35A, for the reasons that are described in Snow. I'm running out of time, but the integrity of the grand jury proceedings requires the court to step back and say, we won't tolerate this, we won't do it, simply because we have to preserve the structural and functional integrity of the grand jury.
But is there any question that the grand jury meant to indict the person for the assault on the woman at the top of the stairs?
It's a different case.
That's the...
Coming out of the
No,
bedroom.
this is
There
this
isn't, but
this
it's
is
the
this is a
Agawam
this
case,
is a
that's
different
right.
case. Is there any question as to whether the jury? I mean, is there any question as to what the grand jury understood they were doing?
Well, they understood that they were indicting for burglary involving an assault on a person we presume was lawfully therein. But the person described to them was not the person who was assaulted. There may indeed have been an assault on that person, but it wasn't the person described to the grand jury. And the point in Mookin is we have to rely on what the evidence was that the grand jury had, not what the universal saw going on, but what the evidence that the grand jury had.
Well,
that's Justice Hand's essential point.
Now, you don't have to go to the grand jury to get into Superior Court. You can get in on a district attorney's complaint, providing the defendant consents to it. Why shouldn't we treat this effectively as a district attorney's complaint where the defendant agreed to the amendment of the indictment?
Well, for one thing, there's no evidence at all waiver of any of that kind of
Well, I'm
thing.
not talking about waiver. I'm talking about an outright agreement.
Well, because that's not what happened, I guess.
He didn't assent to the motion to amend?
He assented to the motion to the amend, but for one thing, the district court complaint also had the same allegation that it would involve the younger woman.
But that's not my point. My point is you don't even have to go to the grand jury. The defendant can agree to a direct complaint. And didn't he effectively do that here?
No, he didn't. What he did was he said, you grand jury, upon which now, because they acted and handed up indictment, and that's what the court is going forward on. So that entirely supersedes anything that happened in the district court. And now the trial court has done something which the grand jury, which gives it its jurisdiction in this case, didn't intend. I mean, the amendment resulted in something that the grand jury did not intend. Because in this particular case, I mean, if there had been a situation where that had happened, then there was no intervening constitutional body that would have changed it. But in this case, there was. And that's how the that's how the Superior Court got jurisdiction.
All right, thank you. Your time is up.
Thanks.
Good morning, Your Honors. Diane Dillon, an Assistant District Attorney representing the Commonwealth. This is an appeal from the denial of the defendant's last motion for a new trial. He's had several. He's had appellate review. In 1997, when the appeals court reviewed this case, the issue was whether or not the indictments were duplicative. And the appeals court specifically said that the evidence showed that the defendant had committed two separate and distinct violations of Chapter 266-14.
Now, that was before the decision in Gordon.
No, it was not, actually, Your Honor.
It was 2 weeks later.
All right.
Or Gordon came. Gordon was decided after the direct appeal in this case, but 2 weeks before this court denied further appellate review. So it occurred while the appellate process was ongoing.
Yes. But nevertheless, they said that specifically, and they even drew a distinction in footnote 2, distinguishing, it would be different, they said, that if it had been a single assault with a number of people that was simultaneous, or words to that effect. I think simultaneous is not a direct quote. But this court has several times said that in 266-14 there are two separate and distinct ways of violating the statute. And the aggravating factors after you get past breaking and entering the dwelling of another in the nighttime with the intent to commit a felony are being armed or arming yourself therein, and or it's disjunctive, committing an actual assault on an occupant. Both of those two aggravating factors have to do with the safety and security and the well-being of the occupants.
Let me ask you the same question I asked Mr. Adams. So supposing a defendant walks into a house through an open doorway, goes up the stairs, and then opens two separate bedroom doors and with the intent to rob each of the occupants behind those doors. Can you have two separate burglaries?
According to the teachings of Tilly and its progeny, yes, you can. Those are two separate breaks. Whenever you go in and you move some obstruction in the house to a material degree, enough to get your body through the door of the bedroom, that is a break under Massachusetts law.
So if a defendant ransacks an empty house and opens 50 doors, including closet doors, each one of those is a separate break. If he entered free and clear, if he just walked through an open front door and opened every door in the house.
It would be under a separate statute because it would be, I don't know if it's a dwelling, I don't know if it's daytime or nighttime, I don't know what his intent was when he entered, was it a misdemeanor or a felony? All of those things.
But whatever it is, I mean, let's assume it's nighttime and it doesn't matter whether it's an intent to commit a felony, but it's just as Justice Spina said, would that be, could the Commonwealth seek 50 or 25 indictments, however
Would
many
we or
doors
would
there?
we? Those are two separate
No, I'm
questions.
asking, could you? Could you?
No, we wouldn't, anyway.
But could you?
I've never considered that. You know, that was just so far out of the realm.
Maybe
of
say 5.
5 separate bedrooms. He
Yeah.
goes into a house here down at the Cape for the weekend. We could. How would we even know it, though?
Fingerprints on the
Could
door.
we charge him or could we prove it?
Fingerprints on the door, the
Fingerprints.
doorknob.
Okay, and they're inside too, so we can prove that he went into that room.
Hmm.
I suppose theoretically we could.
So your view is that every time one opens a closed door, it is a separate crime?
No, Your Honor, I'm quoting what the court has said in Tilly, that anytime there's a material movement of an obstruction in the house, that under our common law is a
So
break.
I'm just trying to make sure. So if I break in a front door, if I push open a front door and then go and open the door 4 bedrooms, that is 5 crimes?
You just open the door, or do you go in too?
I go in. I force open the front door and then I open 4 bedrooms and enter 4 bedrooms.
I think under a literal reading of what the holding was in Tilly, that could be done. I'm not suggesting that it would be proven.
Why does that make any sense? Why should there be the potential for consecutive time as opposed to somebody who entered one door and those bedroom doors were open?
Let me put it to you this way, in the terms of the case that we have and the facts that we have before this. In this particular case, Mr. Bolden went in through the storm door, which was closed but not locked. Once he got in...
That's a break, no question.
That's a break, and he entered.
And it entered.
No question.
Right.
Okay, after he did, he went down into the basement. There was a basement door, which I think there's a reasonable inference, and now he's talking about probable cause before the grand jury, that basement door, because Mr. Glukowski heard something going on. So he got up from watching TV with his wife. He went out to the back rear door, the kitchen door, saw this down on the landing, the 2x4, called to his wife, and he went down, picked up the 2x4, locked the back storm door, and then he went down into the basement where he was assaulted with the 2x4, that the defendant had armed himself therein. He's now unconscious downstairs. When he comes to, he looks up and he sees his wife, and this is according to grand jury what they heard.
We've read the facts.
Unconscious on the landing. And then the grand jury heard testimony, a statement that was taken from her several days later in the hospital. She heard all of this. She went to the back door, and when she got to the door, she had a struggle with someone and she fell down the stairs. When Mr. Glukowski comes to, he sees her at the top of the landing, and she said she fell down the stairs. Mr. Glukowski also said that he saw the defendant run out the rear back door, the kitchen door. Well, if he came out of the house by way of that rear back door and down those stairs, it's not just a reasonable inference, it's inescapable that he made a separate break into the interior of the house by going up into the rear back door into the kitchen, and that's where he had the encounter with Mrs. Glukowski, and she fell down those stairs to the landing.
I'm sorry, I don't know
so
if that
I-
makes a difference. I thought she closed the
Well, it's
cellar
two
door,
separate
not the
breaks.
back door.
But what you're saying, the break into he breaks into the basement,
He breaks into the basement.
and then he breaks from the basement into the house.
No, he breaks from the basement, he goes up to the landing. You have to go up some stairs to break into the kitchen.
From the outside of the house or from inside the house?
The inside of the house, from the
Okay,
landing.
he entered the house once and then broke in to two, I mean, I don't understand your point. There's still
Enter
a
the
single.
interior door.
There's still a single entry into the house, albeit through two different.
Well, but your question was, if he opens another door, is it a separate break?
Okay, so
Okay,
basically.
once he gets in the house and he can do anything he wants, that doesn't make any sense
Well,
in our
I
law.
mean, you could still punish him separately and get a consecutive time for each of the assaults.
We didn't even for assault. But this statute is aimed at protecting the welfare and security. It says that if you make an actual assault on an occupant, that is the aggravating factor, and that is the Commonwealth.
That's how you get life, right?
I beg your pardon?
That's how you get the life.
That's how you get life. And,
Right.
and that's how you can, this is another difference from Levia. When Levia looked at the robbery statute, they said it's got to be the money because they didn't care how much money was robbed in Levia. So obviously that wasn't the aggravating factor. If you look at sections 14 through 18 or 19 of 266, you can see what the aggravating factors are. And in this case, this court has said that the aggravating factors are armed or arming yourself or making an actual assault. And we know that these are inherently dangerous to life because this court has said in Claudio and Rolone that that's why it can serve as a basis for felony murder.
The odd thing here is he also could have been charged with armed assault on the occupant of a dwelling.
Not under Chapter 265 because these happened in July. And Chapter 265 18C was enacted and became valid on December 27th of that same year.
Okay, but stepping back or stepping away from the facts of this case,
Yes.
if it occurred after 265 Section 18C, or 14 rather, the armed assault on the occupant of a dwelling.
18C.
18C.
18C,
He could have been, somebody could be, who under these circumstances, could be charged with the crime of armed assault on the occupant of a dwelling.
After December of 1993.
Okay.
But not at the time of the commission of this crime.
I understand. That's not a life felony, is it? Or is that a 20-year felony?
The sentencing under 18C has been the topic of many
Right.
decisions.
Okay.
And a lot
Getting
of,
amended, right?
it's been amended, it's been criticized, it's been changed.
Is it now a life felony?
I think it is, but I'd go look it up before I
No,
answered
that's
that.
okay.
Is it the Commonwealth's position that Commonwealth versus Gordon was incorrectly decided?
Yes. In essence, it is the Commonwealth's position that it was in. Well, yes, it is. And the other thing.
But do you even need to go there? I mean, I thought your position was Gordon is Gordon, and Gordon you had one break and one entering and then assaults on a variety of people.
And the other thing is I shouldn't say it's incorrectly decided because they weren't considering these issues. The issue raised here is whether or not there can be separate indictments if more than one person was assaulted.
That was what happened in Gordon.
was
The question
Gordon. That's
was
Gordon.
whether you can
I
have
thought-
multiple
But they didn't get
indictments.
into all of this.
Well, and you're arguing, I thought in your brief, that the unit of prosecution is per victim, which is essentially what Gordon said you could not have.
That's what Gordon said, but I don't think that Gordon considered it. And I think that if you look at the other cases that we have, and if you look at the legislative intent in enacting these two aggravating factors, and if you look at the fact that this court has always said that the purpose of the burglary statutes is to protect the security of the home, then the legislature was not just talking about possessory interests. They were not just talking about the things that you keep in your home. Because these aggravating factors have to do with the dangers that are inherent when there is an occupant, especially if someone were armed. And Judge Graney went to great length in Claudio to explain why we should be concerned about a residential burglary at night with occupants when there is an assault. Bad things happen.
Could I ask you this? I think you have argued this, that you have, whatever you might say about the break and the underlying burglary, you've got two separate types of aggravating factor here.
Got two separate fifth,
Right.
you do.
Okay, but the indictments are exactly the same. So how do we know, right? I mean, they read, the name has changed, but they read exactly the same. So and with respect to Mr. Glukowski, actually, 2 of those aggravating factors are true. That he armed, or 3. He armed himself, no, 2. He armed himself and he assaulted an occupant.
That's true. But there's no evidence that he was armed when he assaulted Mrs. Glukowski.
My only point, I think, is that if there were just 2 assaults, in other words, you had the same kind of aggravating factor, although different victims.
I think I would then fall back on my argument that we have to look at the legislative intent, because one of his arguments is this is beyond what the legislature intended. But if you even look at the caption, separated by semicolons, you have burglary, weapons, another semicolon, assault on an occupant. What did the legislature intend when they enacted this? And we know that the legislative intent in the burglary statutes, and it falls in those cognate things, is the protection of people and the security of the home. The security of the home means nothing if you're not there to protect the occupants of the home. And this statute says assault on an occupant.
In this case, if a person breaks into a house and there are 2 people in the same room, and he only opens one door, the door to the house, can the Commonwealth obtain a conviction for 2 burglaries, aggravated burglaries of this type?
I think that the Commonwealth wouldn't under those
No, but could they?
circumstances. Well, now we have 18C, which is another factor that goes into a charging decision. Could you?
Isn't that exactly
I think
what
this
Gordon
is different. No, it's not, because Mr. Bolden could have left.
What Justice Spina just
No,
hypothesized?
because Mr. Bolden could have left the house after he assaulted Mr. Glukowski down in the basement, and he went back up the stairs, and the storm door is right there. He could have left. He didn't have to assault Mrs. Glukowski when she was trying to hold the door closed and not let him in the house. He didn't have to do that. These are 2 separate and distinct acts. As the appeals court said, they are 2 separate violations. And if we have 2 separate and distinct violations of a statute that was meant to protect the safety of the occupants, then the indictments are good, the convictions are good, and the sentencing is good. There is no constitutional violation. And I should rest on my brief on the other question.
Thank you.